just want to give a little bit of housekeeping. I will introduce my esteemed colleagues who are here with me today, and then we will get started on argument. So, my name is Chancellor Aisha Miles. I am the presiding chancellor for Chancery Court Part 3 here in Davidson County. I was elected to the bench in 2022 after practicing with Spencer Fain, Bone McAllister here in Nashville. To my left, I have Judge Blake Neal. Judge Neal was appointed as a circuit court judge in the 25th Judicial District to fill the Honorable Joe Walker III's vacancy. He was appointed by Governor Lee, and he formerly was a partner at Matthews, Rhea, and Neal, and we are so happy to have you here with us, Judge Neal. To my right, we have Judge Stephen Sword, soon to be on our Court of Appeals. He, knock on wood. Judge Sword is a criminal court judge in the 6th Judicial District here in Tennessee. He earned his bachelor's degree from King College and his Juris Doctor from the University of Tennessee. Something that I do a little bit differently is that we sit in the courtroom here. I think it brings more form to the proceedings. And so even though we are seated as a tiered system, we all sit in bunk, each of us having as much weight and authority as the other. So thank you all for being with us today. Before we get started, I would like to have counsel introduce themselves in case we have questions for you so that we know whom we are addressing and who will be lead counsel.
Your Honor, I will begin. I am C.J. Gideon. I'm counsel for Dr. Reach. And as you can probably guess, this is Tom Reach to my left.
Okay, thank you, Mr. Gideon.
Good afternoon. My name is Ryan Gallagher. I'll be representing the Board of Medical Examiners along with my co-counsel Rachel Pelt and Sarah Sedgwick.
Good to see you all. All right, I believe that we are ready to get started. Before we go into argument on the cross motions for summary judgment, we do have some preliminary venue and jurisdictional issues that were briefed by the defendants in this matter, the respondents, that came to the court's attention, that before we proceed in a substantive manner to the merits of the case, we need to address. So I will hear from the state first, since you all raised this issue, and then we'll hear from Mr. Gideon, the petitioner, in regards to his rebuttal on jurisdiction and venue.
May it please the court. Once a 3-judge panel is appointed, 2018-102 controls venue. 2018-102 says, notwithstanding section 44104 and any other law to the contrary, venue for a civil action described in 2018-101A is the county where the plaintiff resides. We have reason to believe that Dr. Reach resides in Jonesboro, Tennessee, in Washington County, and that's found on page 25 of the stipulated administrative record. The revocation letter that was sent to Dr. Reach indicates that his address is in Jonesboro, Tennessee, in Washington County. And so we believe that the proper venue for this case is Washington County. And we believe that venue under 2018-102 is jurisdictional for 2 main reasons. First, it is localized by statute. Whenever venue is set by statute, then it becomes jurisdictional. The relevant authority for this is Hawkins versus Tennessee Department of Corrections. In that case, the court was dealing with a venue statute, 41-21-803. It was a case where an inmate was challenging the discipline that was instituted against him in regards to his refusal to take a drug test. And the venue statute said that the county where the case should be filed is the county where the correctional facility is located. And the court said that because the venue was set by statute, it was localized in that county, it's jurisdictional. Now, the second reason that 2018-102 is jurisdictional is as a matter of sovereign immunity. 2018-101, the three-judge panel statute, is an abrogation of the state's sovereign immunity. It is the state saying, you can sue the state, but you have to do it on the state's terms. And in Article 1, Section 17 of the Tennessee Constitution, it says, suits may be brought against the state in such manner and in such courts as the legislature may by law direct.
But didn't the petitioner in this case file a declaratory judgment action pursuant to 45322, or as the state contends, 225? Doesn't that confer jurisdiction here to the Davidson County Chancery Courts? Are you saying that the three-judge panel statute, in essence, trumps the declaratory judgment 45322 or 225 statute?
Yes, Your Honor. We are saying that the three-judge panel statute trumps 45225 in this case. And there's two main reasons for that. First, under 45225A, it says, the legal validity of a statute, rule, or order of an agency to specified circumstances may be determined in a suit for a declaratory judgment in the Chancery Court of Davidson County. And then, and this is the key provision, it says, unless otherwise provided by statute. The other statute in this case is 2018-102. And then also, if you look at 2018-102, it says that this venue applies notwithstanding any other law to the contrary. So it would trump 45225.
Okay. You may continue with the remainder of your argument.
And so we would respectfully request that the court either transfer this case to Washington County or dismiss it outright. We're not advocating one or the other. We're just leaving that option up to the court. And that is all from the state on that argument.
Okay. Are there any questions, Judge Sword, Judge Neal? Okay. Mr. Gideon.
Yes, Your Honor.
All right. Would
Thank
you
you
like
for
to
an
proceed?
opportunity to respond. I'd like to begin with Rule 12. If you can bring this up on the screen. Can the panel members see the screen clearly?
Yes.
Thank you.
Yes.
Okay. I would like to respectfully point out that there is no exemption under Rule 12 for the state or for counsel from the Attorney General's office. We initially filed this action as the presiding judge identified in the Chancery Court for Davidson County, seeking a declaratory order that what the Board of Medical Examiners had done was wrong. And we clearly identified the jurisdictional basis for that. Subsequent to that, they filed an answer, and if you look at the answer to the original petition, you'll not see any mention of the required affirmative defenses in any pleading filed. You will not see any mention of the required affirmative defenses in the answer to the amended petition. You will not see any reference to jurisdiction or venue in the motion for summary judgment by the state. I respectfully submit that they have waived this 11th hour argument.
Mr. Wells, can you waive, if it's subject matter jurisdiction, can it be waived?
I know your question is directed to me. I'm Gideon.
Oh, I'm sorry.
That's all right. I just wanted to make sure the record was clear.
Yeah, I apologize.
You raise an excellent point. I know you're very familiar with Rule 12.08, and I think that the answer here is this. It can be waived, venue can be waived, if the specific venue provision does not favor that party. In this example, I think the venue-specific provision about the three-judge panel is to benefit people like Tom Reach, not to protect the state. I would also respectfully submit that you should not read too much into the opinion they rely upon. I'm sure the panel's looked at it. It is a decision by the Tennessee Court of Appeals. The plaintiff in that case was a pro se prisoner. It is a pro se case, and the finding they rely upon is dicta. All they had to do in that case was address whether or not the chancellor in that case acted appropriately in sua sponte dismissing the case. She did. The rest of that is just dicta.
But, Mr. Gideon, if we look at Red Wing Catholic Bishop for the Diocese of Memphis, the Tennessee Supreme Court has held that challenges to a court's subject matter jurisdiction calls into question the court's lawful authority to adjudicate any controversy brought before it. So what are we to do with that? Well, the state has cited a Court of Appeals case. We have the Supreme Court saying that if we don't have subject matter jurisdiction, that's kind of a preliminary matter and we can't go any further. What are we to do with the Supreme Court saying one thing, the Court of Appeals saying another? And can't subject matter jurisdiction be brought up at any time?
Rule 1208 has a specific line in it which says that in the event the court determines it lacks subject matter jurisdiction, it can be dismissed at any time. I agree with that point. But I think it can be, in this set of circumstances, addressed as being waived because there is no localization of venue in this case that favors the state that should be treated as jurisdictional. The case Your Honor cited just a moment ago is one where the Supreme Court spends a good deal of time talking about, quote, sloppy language in other opinions, mixing venue and jurisdiction together. And in this case, there is nothing in the three-judge venue statute that says it should be treated as jurisdictional. In addition to Rule 12.02, there's also the local rule here that requires if you're going to move to dismiss a case, you have to file that motion not less than 14 days before it's going to be heard. That didn't occur either. So I think under these circumstances, I respectfully submit that our Supreme Court would conclude that this defense has been waived, that venue is not jurisdictional, that the specific venue statute here is for the benefit of and at the election of someone like Tom Reed and not to protect the state as it was in the two cases cited by the Attorney General's office.
But isn't there another case, Berlinger versus the Department of Safety and Homeland Security? And that says challenges to subject matter jurisdiction cannot be waived and may be raised at any time, even for the first time on appeal. So how do we look at that case? And I'm happy to give you the key site. It's a 2019 Westlaw 360337 at page 3. How do we look at that and the local rule, which says, I hear you on the motion to dismiss. They already answered. I follow you on that, but we have, the Court of Appeals and the Supreme Court saying even on appeal, even after the trial court has finished its ruling, subject matter jurisdiction can be raised even then.
Well, may I repeat just for a moment how we got here to begin with? We filed suit in the Chancery Court for Davidson County under the precise statute you identified. So there was no question the Chancery Court of Davidson County had subject matter jurisdiction. And I respectfully submit still does today. In addition to that, there subsequently was an action seeking a declaratory judgment that fell within the criteria established by 20-18-101 that sets the basis, the subject matter jurisdiction for this court. The venue statute that goes with that, I respectfully submit, is not jurisdictional because it says it may be filed in the county of the residence of the plaintiff or in the county of any plaintiff or if somebody resides out of the state in Sumner County. It is clearly not designed to protect the state as it was in the two cases they cited. The case against Chip Saltzman, they relied upon Section 104 that says each department of the state shall be deemed to be residing in Nashville, Tennessee. It was dismissed. And the other case, the one I mentioned to you, had a specific statute that said if you're a prisoner and you're suing about the conditions of your confinement, it has to be filed in the county where the facility is. Those were treated as localized. They're different than this. And as to the final case you just cited, Your Honor, it wasn't raised. We got this response raising the issue of venue last Thursday. We haven't had much time to address it. And that's one of the reasons why Rule 12 says bring it up so it can be addressed and does not interfere with progression of the merits.
I've got just one quick question for you, but before I do that, let me just compliment the attorneys. Mr. Gideon, you've done an outstanding job. I've read all of your filings and representing Dr. Reach and the state as well through the Attorney General's office. I always brag on the attorneys in Knox County. I think we got the best bar. You have challenged that assumption, so very well done. Just to be clear for the record, you're not claiming that Dr. Reach is a resident of Davidson County, correct?
No, I'm not. And I think one of the things you will find if you've looked at all the materials, we're not going to play any games with anybody. We're not going to hide anything. But this is something where this action was filed well over a year ago. And then initially the state said we didn't seek a declaratory judgment. And we had to go back to the Board of Medical Examiners and ask them to address a constitutional issue, which I knew they wouldn't touch. They won't touch that. They decline that consistently. So we come back with an amended petition. And then the Thursday before we finally get close to a hearing, they raise the issue of venue. And I respectfully submit that's an abuse of the process. This should have been raised a year ago. And I know I've made myself clear, but I don't think every venue defense is jurisdictional, Your Honor. And I think they're conflating the two too easily.
Mr. Gideon,
Yes, sir.
trying to distinguish those two cases by saying that the legislature imposed those venue statutes, making them subject matter jurisdiction to protect the interest of the state.
Yes.
Is that your interpretation of those cases? Do the cases talk about protecting the state in that matter, or are you just saying that's why you think, that's the legal reason you think that was done?
That's the interpretation of an advocate. That is not language from the opinions.
Cool.
But
Thank
I do recall, as I'm sure you do, Your Honor, expanding the available jurisdiction for challenges to board decisions in Nashville to other outlying counties was sensible. It was designed to permit bringing the government to the people. But I don't think it's designed here to block Dr. Reach from proceeding with his case in a timely fashion.
And Mr. Gideon, if you don't mind yielding the podium for a moment, I'd like the state to respond to your concern about the lateness of the jurisdictional issue being raised, because I have the same concern myself.
I will sit down whenever I'm told.
I would like to hear from the state on why this was just brought up now.
Yes, Your Honor. So we raised it as soon as we were aware of it, at the earliest possible opportunity once we
Mr.
discovered
Gallagher, I know you're not coming before this panel and saying that on Monday, this is the first that you have heard of this. You will have had this case. You have known about this case. The Board of Medical Examiners, with all due respect, is the one who sent the letter. So I know that's not what you're saying. Why are you doing this now?
We realized the jurisdictional issue in responding to Mr. Gideon's motion for summary judgment. And it was just in the process of reviewing the record closely, looking at all the statutes again. That was when we raised it. That was when we noticed it, and then we raised it in the first pleading that we possibly could. And the state isn't trying to play a game here. We would prefer this to be in Davidson County. My office is a block down the street. We are asking this to be transferred to Dr. Reach's home county of Washington, which is 4.5 hours away. So as a matter of convenience, this is certainly not in the state's favor. We are just trying to get the law right. That is the only thing we're trying to do here.
When you all filed your motion to dismiss on November 30th of 2023, you did not raise this issue.
That is correct, yes. We did not raise this issue in that motion to dismiss.
So that really was your first response to this court. It was a motion to dismiss, and it wasn't raised. And the court finds it to be, the court is concerned by the state doing this now. This is not the first time that you've been, it may be the first time that you all have been before this panel live and in person, but it's definitely not your first pleadings in this case.
Yes, that is correct, and I don't dispute any of that. Again, we raised it once we became aware of it. We weren't aware of it at the time we filed that motion to dismiss, and we were aware of it after Mr. Gideon filed his motion for summary judgment, and we raised the issue in that response.
Is it not waived?
I'm sorry?
Is it not waived?
No, it's not waived, Your Honor, because it is an issue of subject matter jurisdiction, and those issues are not waivable because they go to the court's authority to hear a case. And another case that supports this argument that it's jurisdictional is the case of Southwest Williamson County Comity Association versus Saltzman. And there, I think it's even more clear than the localization argument. There, the court is discussing Article 1, Section 17. Suits may be brought against the state in such manner and as such courts as the legislature may by law direct. And so that when we're dealing with the state's sovereign immunity, that is jurisdictional. That's what that case stands for. And in this case as well, we're dealing with the state's sovereign immunity. And so this is jurisdictional. And subject matter jurisdiction issues cannot be waived. And unless there are any further questions from the court on this point, I will sit down.
Your Honor, may I briefly respond to the reference to the case against Chip Saltzman, please?
Yes, Mr. Gideon.
Thank you. I trust that the members of the panel have all read that specific case, and that is the only case where each side was actually represented, the only opinion they're relying on where each side was actually represented. And in that case, Your Honor will recall, there was a big brouhaha over the Commissioner of Transportation's decision-making over routing 840 through Williamson County. The plaintiffs in that case said, this deals with land in Williamson County. This is properly cited here in Williamson County. The state, representing Chip Saltzman, the then Department of Transportation Commissioner, raised the issue of TCA 4-4-104A, which officially designates the chairman of each department of government as being officially residing in Davidson County. That was the basis for the dismissal. That was to protect the state of Tennessee. We complied with that specific statute by suing here in Davidson County, in the Chancery Court, in the county where the Department of Health is housed. That opinion does not help the state with respect to our argument.
But doesn't it help the state with the argument that if the state is going to allow itself to be sued, if it's going to waive its sovereign immunity, then the state gets to decide exactly how those suits take place, and one of those things the state gets to do is set the venue, and at that point it becomes not just venue, it becomes subject matter jurisdiction because the state has to specifically describe how you bring a suit against it.
That's the distinction this panel must address, and that is I respectfully submit that the statutes that set specific venue requirements for actions against the state like that could be treated as jurisdictional. But one that is set for the convenience of the plaintiff in an action against the state may be waived by that plaintiff, Tom Reach, who waived it here. In those settings, the rules that apply to the state should have even more force and effect, and that is, you can't just sit on an alleged defense of improper venue and call every venue statute jurisdictional because it has a formula in it. That's not logical. Thank you for the additional time.
Well, one question I have for you. So when you originally filed this case, it did not request a three-judge panel, and then there was a request for the three-judge panel. And once the three-judge panel came into play, you know, there was a different set of rules and statutes that had to be complied with. So if you were to waive, or can you speak with me about that?
Yes. I don't think anyone would argue that when we initially filed this action, we relied on the appropriate venue statute that specifically says Chancery Court for Davidson County to challenge an action of the Board of Medical Examiners. Entirely appropriate. Subsequently, after seeking a declaratory judgment that this particular statute was unconstitutional, it was apparent that this case met the criteria for 20-18-101 for this three-judge panel.
Well, didn't it, it had a little bit of an interesting procedural posture in that it was denied three-judge panel status, and then there was another request for three-judge panel status. So is it a three-judge panel case? Is it not? You know.
I think Your Honor will recall that your order denied the three-judge panel initial request.
Well, I don't know if it was my order. I don't know that I have. I'm not the presiding judge, so I don't know that I have that much authority. But
it was because there was not an explicit request for a declaratory judgment.
okay.
That was the reason why we initially went up the chain of command and came back down and started anew. But there was never any issue as to jurisdiction. Then we all agreed that with the claims being made, the criteria in Section 101 that sets the subject matter jurisdiction for this three-judge panel were met. But then from that date until last Thursday, during the life of this case, there was never any argument by the state that this was an improper venue to adjudicate the issues in this case. Almost 2 years.
Mr. Gideon, I agree with you, and I think these judges do too, that it's waived if it's not subject matter. The only question is whether it's subject matter, and you can't waive subject matter. I guess my question is, you're talking about the interest of the state in setting the venue provisions to protect the state, and it's my recollection that one of the large purposes of the three-judge panel statute was to prevent everybody from coming to Davidson County Chancery Court anytime they wanted to challenge the constitutionality of a statute. And so that have any effect on the subject matter jurisdiction, the legislature's intent when they passed this statute?
Well, Your Honor, my understanding was to permit people to litigate issues that are affecting them directly in their counties of residence. As you know, we've got a large state, a lot of counties, great distance from here to Bristol.
Yeah, from here to Covington, where I drove in from this morning. So
their cases in Bristol are no less important than the cases for the people that are cited here. My understanding, without looking at legislative history, but being actively involved in politics, was this was designed to be citizen-friendly, not so much to protect the state from the Chancery Court in Davidson County.
And I didn't mean, not implying to protect from, but just to prevent everything from being filed here if that's where everybody wanted to file.
Right.
But fair enough.
I wish I had a case where I could identify the citation for you where Judge Swofford said, Gideon's right. I don't.
Yeah.
But I respectfully submit that's the sensible interpretation that I think our Supreme Court would accept.
Well, let me ask you this. In the interest of getting your client some resolution one way or the other, if we denied their motion and then we litigate this case and we hear it on the merits, and then we get reversed on the subject matter jurisdiction, and then we got to come back and have a new three-judge panel appointed and start it all over again. It's not really to your client's benefit there, is it?
No, and this is an unforced error that's not my client's fault.
No, agreed.
If, in fact, the state had complied with the same rules we've all got to comply with, then we would have adjudicated this issue a year and a half ago. And that's the thing that bothers me so much about this, and I'm not heaping criticism on my opponent at all, but it is irresponsible to sit on something like this until the Thursday before a hearing on something this important. This man lost his license, summarily revoked, in 2023. It's not as if he lost his driver's license and had a hearing and then it was reinstated. He hasn't had a license to practice medicine in the state of Tennessee for almost 2 years. It's too late to raise this. And I frankly think in this set of circumstances, I respectfully submit, our Supreme Court would not say that this venue statute is jurisdictional.
Would you then, Mr. Gideon, can you help me identify whether or not you think this action is transitory or not? If we're looking at Hawkins versus Tennessee Department of Correction, are you familiar with that case?
Read it over and over again. That's the case where the plaintiff was the pro se prisoner.
Mm-hmm.
Yes,
So do you think this is a transitory action or no?
I think it is. And Your Honor, you will recall from that opinion, there was a very specific statute. In fact, I can give you the citation, I think, that it's 41-21-803 that made it very, very clear, and I think it was probably to assist witnesses and perhaps to protect Corrections Corp. But it said that any action involving a inmate, involving either a state prison or a private prison, had to be filed in the county in which the incarceration occurred. Now, I respectfully submit that is an example of state protective venue legislation. And I will yield and sit down unless there's another question. Chancellor, do you have?
Let me confer with my esteemed colleagues. I do not think we have any additional questions. So before we are able to proceed to the merits of this case, we're going to have to make a ruling on this. So we will step off the bench briefly and take a recess and then come back out and tell you all what we are going to do. Okay?
All right.
Ready, Chancellor?
All right. So we have taken some time to review the questions before the court regarding jurisdiction, subject matter jurisdiction, whether or not this is a transitory action, and whether or not this is jurisdictional or subject matter. Judge Sword, would you like to say
Yes,
something?
thank you, Chancellor. In our discussions, one of the consensus that all three of us came to pretty quickly is our extreme disappointment in the lateness that this challenge regarding jurisdiction has been raised. I'm certainly aware of how things come up at last minute, but this has been pending for quite some time. Dr. Reach has been waiting for his day in court, and so all three of us, understanding how difficult your job is, the law is complicated, but this seems like it's something that's fairly straightforward that should have been raised at a much earlier date. And so on behalf of the court, I would apologize to the plaintiffs and the plaintiff's attorney for the lateness that this has been raised, but it does put us in a very difficult situation where we have to address this issue on the merits. And so I think Chancellor Miles is going to announce our decision.
Yes, in reviewing, so first of all, I want to echo Judge Sword's sentiment. This case has been pending for quite some time, and, you know, frankly, I think it's unconscionable to sit on something like this in regards to subject matter jurisdiction when it comes to the state. However, in reviewing the case law, we feel like it is clear that we do not have subject matter jurisdiction because, Dr. Reach, you do not reside in Davidson County, and the three-judge panel statute is clear on where the case must be brought when you're sitting three judges en banc on such a constitutional issue as this. So we will be transferring this matter to Washington County. Perhaps this gives counsel an opportunity to look at their pleadings. You see what the state and or the petitioner has raised as maybe weaknesses in the argument, and you may have some additional time to brief that. We will put down an order transferring this matter to Washington County, and we will also alert Justice Kirby of this matter as a new panel may need to be appointed to the case, seeing as how jurisdiction is not proper here in Davidson County. Mr. Gideon, would you like to say something?
Thank you. I am very disappointed as well, but I respect your decision.
Mr. Gallagher?
Disappointed the court for its time today, for its ruling.
Okay. All right. We will get that order down, and we will alert Justice Kirby of this change. Thank you. We're adjourned.
All rise.